Dear audience, we are very pleased to present you this second webcast in the three-part series of the enforcement of anti-bribery and anti-corruption laws in various countries. Our first webcast discussed the UK Bribery Act, which received royal assent on April 8, 2010, and will be enforced in April 2011. This webcast will discuss China. As one of the fastest growing economies in the world, is also making significant efforts in building up its own anti-bribery system. Even though China has not had a standalone anti-bribery law, many new legal interpretations on existing criminal law with regard to anti-bribery and the new regulations have been launched in the past 3 years. In this webcast, we are focusing on the new laws and regulations related to anti-bribery in China and its implications for directors and officers with Mr. Zhang, partner of King & Wood, and also Mr. Patrick Zeng, Zurich, China. So my first question goes to Zhang. What is the Chinese anti-bribery and anti-corruption legal framework? And what is impact on directors and officers from the recently launched the legal interpretation on anti-bribery on commercial transactions?
China maintains a two-layer legislative regime in terms of the anti-corruption and anti-bribery, namely being the Chinese criminal law and the China anti-unfair competition law. And the Chinese Communist Party, as well as the State Council, also issued various regulations governing its party members as well as the state-owned companies. Those regulations would not directly apply to multinationals, but when multinationals are doing business with, say, for instance, the state-owned companies, those regulations would apply. Mm-hmm. The criminal law actually was first introduced in 1979 with various amendments, and the latest version came out in 2008. And during that period of time, there are different judicial explanations being issued by the Supreme People's Court, Supreme People's Prosecutor's Office, as well as the Minister of Public Securities. Then those introduction of various judicial explanations actually tried to expand the governance and application from the pure state agency employees towards all employees in various commercial entities. The state entities or non-state personnel from accepting, when they are accepting the briberies, mm-hmm. or when they are giving the briberies, those mm-hmm. are all the issues that has been prohibited by the criminal law.
Yeah.
The criminal law has a very specific provision which says whenever the criminal offense occurs in China, mm-hmm. regardless who is the offender, a foreigner or a Chinese individual, yeah. they should all be subject to the PRC criminal law. Mm-hmm. So multinationals and its directors and officers must bear this in mind. And also the newly launched the criminal cases and criminal bribery judicial explanations actually have been the latest development in this regard. Mm. And it has explicitly carved out a liability for the employees and the staffs of a company who is involved in commercial bribery. Mm-hmm. So the foreign companies, when you are complying with FCPA or other anti-bribery acts in UK, for instance, you must always bear in mind that you have to comply with the PRC anti-bribery and anti-corruption law.
What will be the immediate and the long-term expected impact on companies and their directors? And then also, what examples can we take from other jurisdictions with the similar laws?
Actually, in the past 2 years, we have seen a increasing number of the anti-bribery investigation against the foreign companies in China. Mm-hmm. Some of them has become very, very high profile in China.
Sure.
Yes, everybody know that.
Yeah.
Given the changing legal and working environment in China, yeah. the immediate impact and the challenges, there will be making every key staffs and director and officers in China operation understand the application of the laws, administrative regulations. So in terms of the long-term impact, I think the key challenge will be setting up the corporate governance policies to prevent the legal liabilities triggered by the possible violation on the anti-bribery practice. So given that the foreign companies are subject to the laws, both in China and from the law in their home countries, they're actually facing a higher the legal exposures during their daily operations. So the corporate governance systems must be effectively integrated into the two different legal requirements.
Directors and officers want to know what are the fines or the penalties that could be imposed under the China anti-bribery law covered under our standard D&O policy? And then also, what about the costs of defending these investigation and proceedings?
Actually, I think this is a very good question and very common questions asked by my clients. And I think before answer these questions, I think it is important to understand whether or not such kinds of fines and penalties are even insurable under China law.
Legally speaking, the fines and penalties is not insurable.
Not insurable.
It really depends on whether it's the individual or the entity that has committed the offense. In terms of the individual liability, normally it would be fines and possibly would even be imprisonment. But also for the business operators, the penalties that is monetary could range from 10,000 up to 200,000 RMB.
Okay.
I think as these kinds of the background, fines and penalties associated with these kinds of enforcement actions they typically would not be covered under D&O policies.
Okay.
Actually, all the fines and penalties are excluded via the definition of the laws under the standard D&O policies. However, the defense fees, or we call defense costs, at least for the individual, should be covered. So actually, this is the reason you should read your policy very carefully to make sure that the coverage for the defense costs are in place.
Yeah, sure.
And also, so that being said, that some of the D&O policies, they do try to extend the coverage for certain fines and penalties against the insured, the director and officers in accordance with the UK Bribery Acts, the US FCPA, and other anti-bribery laws, provided such kinds of insurance is not against the policy, is not against the public policies. However, I don't think this is the case in China.
Okay, absolutely yes. How can the directors protect themselves and also their companies from this kind of exposure?
I guess two aspects. The first of all, the directors and officers must keep tracking the fast-growing legal environment in China. And due to the very fast changes in the commercial business operating environment in China, so the lawmakers in China has been improving the existing legal system very rapidly. For instance, in the last 3 years, there have been a lot of new laws and regulations coming out to monitor the fast-growing legal environment in China, as well as to have a sound system. Keep yourself communicating with the authorities would be an effective way. The other way is whether you have an adequate procedure defense. Directors and officers should ensure that their company have adequate procedures that is already in place to prevent bribery, such as a anti-bribery compliance policy or a code of conduct.
Yeah.
And is there a training around this policy and how that has been enforced? And also, what are the penalties for the employees who do not follow the policies? And what are the additional information that has been adopted in terms of the internal control system, such as whether we have a standard contract that has a provision in the contract preventing the commercial bribery.
Sure.
And whether we have a clear policy on corporate gifts and hospitality,
Sure.
giving the gifts. what are the policies and facilities in terms of the internal whistleblower providing a clear channel for the staff to raise concerns in a safe and a confidential way?
Okay.
Whether you have a robust screening system for third-party payments.
Yeah.
And what are the sort of the effective procedures for investing and resolving any problem?
You just mentioned the whistleblower. My question is about, is whistleblower in practice encouraged in China? And how may this impact the liability of D&Os in their China operation?
In general, there is no legal requirement for an employee to disclose the wrongdoing of its employer. The Chinese whistleblowing is usually anonymous, as you can imagine, and quite often, it's single accusation oriented. Would not be involving a lot of accusations. But normally, investigation should focus widely and then progress towards the claims most likely to reveal the serious liabilities to the company. But unfortunately, the shift towards the high specific facts and evidence that quite often is very difficult part of the procedure for all concerned. For several reasons. But no matter what is the situation for the whistleblower in China, the D&O policy provides the coverage for the claim.
I think no matter what is the situation for the whistleblower in China, the D&O policies did that provide the coverage for the claim arising out of the whistleblowers in two aspects. The first of all, under the employment practice liability sections, the actual and alleged illegal retaliatory treatment on the employees for their whistleblower activities is covered. Secondly, under the insured versus insured sections, a claim brought by insured persons or any directors and officers in their capacity as a whistleblower is not excluded. So basically, this is the insurance coverage for the whistleblowers in D&O policy.
Where is this all leading for the D&O market?
All these changes in legal environment and increasing needs from the client side will definitely lead to changes in the D&O market and insurance. They having seen some of the very high-profile bribery litigation against the foreign companies in China. So the insurance underwriters has been fully aware of the anti-bribery exposure in the foreign companies, which has been driven up to a record high level by both the legal changes in China and the law requirements from their home countries. So during the underwritings, more attention will be paid to the company's internal control and their corporate requirements on anti-bribery.
Yeah.
Given the complexity of the anti-bribery claim, the insurer shall also enhance its claim handling the capabilities and working more closely with the law firm in handling these kinds of the claim. And to enhance the corporate governance of insurance companies to the insured companies, in addition to providing the insurance coverage, insurer may also provide the corporate government trainings on the topic of the anti-bribery practice.
Thank you, guys. Before we conclude this session, let's have 3 key messages to take away from this conversation.
First of all, a corporation must have a sound internal control system. And secondly, especially for multinationals, when they are exporting to multi-jurisdictions, they possibly would have to be fully aware that they are subject to the anti-bribery statute, not only in their home jurisdictions, but also in their guest jurisdictions.
Yeah.
And in some of the jurisdictions, such as China, simply because there is no single specific legislature would not mean that the government would not be enforcing the actions. So the multinationals and its directors and officers must be fully aware of this, and they must prepare themselves for this.
Because this is a very complicated liability insurance, I think the policyholders should read their policies very, very careful and must ensure that the policy is as generous as possible as what is allowed in the way of coverage for the fines and penalties. the policy coverage must be structured to provide the cover for the individual director and officers who is intended to be protected, and also not simply for the company.
Absolutely, yes. Yeah, okay, great, thank you guys. I'm afraid that is where we have to leave things for now. Please tune in for our final webcast on anti-bribery FCPA and the ramifications in the US market, where it all began. If you want to end your points or you have any questions, do please email us at directorsforum@zurich.com. Finally, thanks to our panel, Mr. Zhang Yi, partner of King & Wood, Mr. Patrick Zeng from Zurich, China. Thank you for watching. Goodbye.